Hello, everyone, and welcome to Thursday Talks with Chug. Each week, we cover pressing topics that matter to you and your business. I'm Arianna Gonzalez from Chug, attorneys and CPAs tuning in from our San Diego office. Please join me in welcoming partner and attorney Swapnali Kelkar from our Edison, New Jersey office. Hi there, Swapnali, and welcome.
Hey, hi, Arianna. Thanks for inviting me on this show again.
Thank you so much for taking the time to be here with us. For today's topic, we're going to be talking all about the U.S. Department of Labor's Project Firewall and what H-1B employers must know to stay compliant. Just a quick disclaimer before we get started, this conversation is for informational purposes only. It does not create an attorney-client relationship. So if you do have questions, please comment them below or email us anytime at info@chug.com. So let's get right into it, Swapnali. Let's start with the basics. Can you tell me what is Project Firewall and what prompted its launch?
Yeah, sure. So the Project Firewall is an enforcement initiative announced on September 19, 2025 by the United States Department of Labor. Now, its main purpose is to safeguard the rights, wages, and jobs of highly skilled American workers in the context of the H-1B visa program by ensuring that employers who use the program should prioritize the qualified Americans and do not abuse the process. So I would say this initiative is nothing but stemming from the presidential proclamation, which was announced on September 19, restricting the entry of the H-1B workers. Now, through this project, the department will conduct the investigations of employers to maximize the H-1B program compliance. And for this, the Secretary of Labor will personally certify the initiation of these type of investigations.
Now, you mentioned to safeguard our rights. So can you tell us what is the main goal? Is it protecting American workers, enforcing visa rules, or is it both?
So I would say there are two objectives intertwined here. First one is to protect the American workers, and second one is to enforce the H-1B visa rules. Because historically it has been argued that the H-1B visa program has been abused and been misused by many employers out there. So basically, the Department of Labor's role is to protect the American workers through carrying out certain investigations through this Project Firewall, and at the same time seeing that H-1B employers are basically complying with the H-1B visa rules.
And can you tell us who within DOL or associated agencies even is leading the initiative and which divisions are involved in this?
Yeah, so from the DOL lead unit, the agencies which will be integrated in this Project Firewall will be, the first one will be the Employment and Training Administration. Then it will be the Wage and Hour Division, the DOL's Office of Immigration Policy. And at the same time, there will be some key federal partner agencies who are outside the Department of Labor, who will also be involved probably in these type of investigations. And those agencies will be USCIS, maybe Equal Employment Opportunity Commission, Department of Justice Civil Rights Division, etc. So I think once this launch will happen and once these investigations will start, we will have more broader idea and more clear idea about which all agencies are basically involved in this particular project.
Got it. And what kinds of behaviors or employer practices will trigger investigations under Project Firewall? Do we have any information about that?
There is no such exhaustive list which is announced by the DOL, but as we know, what is the object behind this project is to ensure that H-1B employers are complying with the H-1B visa rules. So from that, we can certainly interpret that all those employers who are not prioritizing the qualified US workers when they are hiring in the H-1B context. So if the H-1B visa is being abused, if the US workers have been refused the opportunities at the cost of US workers, then certainly that may trigger this type of investigation. If employers, H-1B employers are misusing the H-1B visa program. For example, maybe like, replacing the US workers, or maybe underpaying the H-1B workers as compared to the US workers, or not complying with certain H-1B visa rules, which we are definitely going to discuss in this session later. So if the employers are not complying with the H-1B visa rules, definitely these type of behaviors from H-1B employers may trigger the investigations through Project Firewall.
And can you elaborate a little bit on the primary compliance obligations that H-1B employers should be aware of right now?
Right. So, as all H-1B employers are aware that before even filing the H-1B petition, the most important document they have to file with the Department of Labor is a labor condition application. And when a labor condition application is filed with the Department of Labor, basically every employer is committing that he will comply with certain, obligations or certain compliances. Now, once the LCA is submitted and it's certified, the employer is basically obligated to comply with the first requirement, which is a wage compliance. Now, what is a wage compliance? The wage compliance is when any H-1B employer is filing a petition for any H-1B employer, he should ensure that he is paying the H-1B worker at least the higher of the actual wage paid to similar employees at the company, or the prevailing wage for that occupation and location, because this helps preventing undercutting US workers' wages. So the first compliance which all H-1B employers needs to be mindful about is the wage compliance. They should ensure that they are paying their H-1B employees the higher wages. Now, the second compliance is about the working conditions. So employers must ensure that the working conditions for US workers are not adversely affected. So meaning thereby, maybe the hours, the benefits, or any other working conditions, or any travel requirements, or any such things which are pertaining to the working conditions, it should not be adversely, the working conditions for US workers should not be adversely affected just because the employers are hiring the US workers. This means that they can't use the H-1B workers to either replace or displace qualified US employees. So employers have to be mindful about the working conditions as well. The third compliance for H-1B employers is about maintaining a public access file. Now, what is public access file? Basically, public access file is a document which every employer should maintain for every LCA the employer is filing. And this document includes the LCA, the wage data, the related records showing compliance. And this document or this file must be available for public inspection. So this is another requirement for the H-1B employers. The fourth compliance which employers has to be mindful about is notice requirements. So this is basically the posting of LCA notice. So whenever any employer is filing the LCA, before even submitting the LCA, he has to publish a notice notifying other workers through these postings that an H-1B application has been filed. So this is another. The fifth requirement is about any changes in employment conditions. So for example, maybe initially the H-1B employer is intending to place a particular worker at one particular location, and subsequently, due to some other opportunities, now he wants to move that worker from one work site to another work site. Then employer has to be mindful about, he should check whether a new H-1B petition, an amended petition, is required to be filed. If not, whether he has complied with the LCA posting requirements. If there is any change in the job title, if there is any change in the salary. So employer should always keep in mind all of his documents, all of his records regarding his H-1B employees' employment details should always be updated. Finally, I would say employers must comply with the record keeping and good faith obligations. Like they must keep the payroll for all their H-1B employees. They should retain the public access files. They should maintain all the LCA documentations. And in case if any investigations triggered, they should definitely cooperate with the DOL in the investigation process.
Wow, very thorough information there. Thank you for covering all of that for us. I do want to get into public access file requirements and ask you a little bit about that. Let's start with the most basic question. What is a public access file and why is it required?
A public access file is a mandatory record that every H-1B employer must maintain for each labor condition application for each LCA they are filing. Basically, this file will have all the information regarding that H-1B employee's working terms and conditions. It will have the information about the title, about the wage, about the actual wage memorandum, whether the copy of the LCA has been given to the employee and all that. So whenever any LCA is filed, like when this public file is needed to be created by an employer. So once the LCA is filed, the public access file must be created within 1 working day after the filing of the LCA. And this is required, as we have discussed before, that this is required for a public examination or public inspection. So if anyone who wants to review any information pertaining to that particular LCA, the employer should make his public access file available for the inspection. Because as we have seen that before filing the LCA, the notice of filing is required to be posted. So basically, before filing the LCA, also employer has to inform the workers in his organization or people around that work site that there is such type of position available for an H-1B worker, and the employer is going to file an H-1B petition for that. So likewise, when the LCA is actually filed, it's mandatory for the employer to create the public access file.
Understood. And can you tell us what documents must be included in the PAF?
Right. So as I said, the public access files are created for each LCA file. So it's not employee specific, but it's LCA specific. And therefore, the public access file should contain the certified LCA. It should also have a wage rate paid to a document which can explain that the actual wage rate paid to the H-1B worker. It should also have a document explaining how the employer has calculated or arrived at the actual wage. Now, we usually say that the public access file should have an actual wage memorandum. That means there will be a prevailing wage. There will be some set of wage levels given by Department of Labor for each specific occupation. And if employer is probably offering higher than the prevailing wage, then the employer's actual wage memorandum should basically state how he has arrived to that particular figure or how he has arrived to that offered wage, and what are the criteria he has considered while calculating the actual wage. Most of the time, the actual wage is determined after considering the employee's education, his qualification, his experience, probably the complexity of his job role, his job duties. At the same time, the wages offered to other employees who are also employed in a similar kind of occupation in around the same intended employment area. And basis all this, the employer should actually calculate the actual wage, and he must include this memorandum in his public access file. He should also put a documentation which can confirm the prevailing wage from whatever source he has procured that, but he must keep that document as well. He should also add the summary of benefits offered to US workers and H-1B workers. And as I said, this may come under the working conditions. So this once he include this, he can comply with the working conditions obligation as well. Evidence of LCA posting or electronic, either through a paper notice or electronic notice, but the notice of filing, a document which confirms that employer has posted the notice of filing, that should also be included in the PAF. So I would say these are the basic documents which should go in the public access file maintained by the employer.
Perfect. That is pretty straightforward. And how long would you recommend a PAF be retained?
The PAFs are required to be maintained 1 year beyond the end of the LCA's employment period, usually a period for which that particular H-1B employee is employed. For example, every LCA is H-1B LCA is filed for 3 years. So if the employee is employed for a complete period of 3 years, then it's mandatory for the employer to maintain PAF for that particular LCA 1 year beyond the end of the LCA's employment period. Now, let's take up some other situation where the LCA was filed for 3 years, but maybe the employee resigned or he left or he was terminated, for example, by the employer. Then in such cases, whenever the employment is terminated or if employee resigns, it's mandatory for the employer to probably submit the revocation with USCIS requesting to revoke the H-1B petition or withdraw the H-1B petition. At the same time, employer should also go ahead and withdraw the LCA. And once the LCA is withdrawn, whatever is the day on which the LCA is withdrawn, from that day, employer should maintain the PAF for 1 year. So either by the end of 1 year from the end of LCA's employment period, or maybe the day when the LCA is withdrawn, whichever is later.
Who can inspect the PAF?
PAFs can be inspected by anyone. If I want to check a PAF for a particular LCA, because maybe I am working in an organization, I saw that there is a notice of filing for a particular LCA, and if I felt a need that no, I want to understand more about this particular job requirement and all that, I can request the employer and he must provide me the PAF for my inspection.
Good to know. So we do have a lot of employers who watch our podcast. So I want to ask a little bit about employer wage obligations. What is the required wage rate?
Yeah, that's a good question. What is the required wage rate? Because uh, whenever the wage rate comes in the picture, the usually the employers come across with two terms. One is the actual wage, and the other one is a prevailing wage, which is determined by Department of Labor. So for every occupational classification, there are 4 levels of wages which are determined by the DOL. And those are the minimum wages which every employer should offer depending upon the area of intended work location and depending upon the complexity of the job, their educational requirement. There are multiple factors basis which we basically determine what should be an apt prevailing wage for that particular position. Now, in case if let's assume that a prevailing wage for a particular work location, maybe Edison, New Jersey, for a software engineer is 100K, and if the employer in his offer letter is mentioning that I'm ready to offer you 120K, and even in I-129 petition he wrote that he is ready to offer the employee the 120K, then in that case, whatever is a higher, either the offered wage, which is the actual wage, or the prevailing wage, whatever is the higher of both of them, employer must offer him the higher wage. So in this example, if employer committed through his offer letter, through his H-1B petition, to offer or pay 120K, though the prevailing wage is lesser than that, it's mandatory for employer to pay him 120K.
Understood. And when do wage obligations begin?
Yeah, so this is a very crucial and very important question because many times it happens that the employers do not actually understand from when actually the wage obligation is going to start. So the wage obligation usually begins on the H-1B employee's start date as listed on the I-129 petition, or when they actually report for the work. So whichever comes first. So for example, if employee is already in the US and he has already showed up for his work, he has already joined the employer, the day when employee presents himself for work to the employer, the obligation begins.
And are employers required to pay even during non-productive periods such as benching?
Another good question because pretty often I get this question from small consulting firms. where they say that we right now don't have a project. Can we keep the employees on our payroll, but we are not actually we can't afford paying them the prevailing wage or the actual wage, whichever is higher. So benching is not allowed under H-1B program because the whole H-1B program is crafted with an intention that the skilled workers, highly skilled workers, must have a work available for them so that they can utilize their knowledge. Now, if unfortunately the work is not available to them, employer just cannot say that, see, there is no work available for you and I cannot pay you. That's not allowed. So if the employee is non-productive for a particular period of time, the H-1B employer is still bound to pay him the LCA wage, either the prevailing wage or the actual wage, whichever is higher, for that entire period. Employer cannot get away with that obligation. So if the non-productive periods are because of lack of work or because of any delay caused by the employer cannot escape his liability, but he has to pay the actual wage or a prevailing wage, whichever is higher, to the employee.
Got it. Can you tell us what happens if the employee chooses to take unpaid leave?
Yeah, so we just spoke about the non-productive, hours and whether the employer should pay the wage during those non-productive, working hours. Now, if the employee is voluntarily being absent from the work, maybe because of a vacation or maybe because of medical leave or maybe for some other reason, then in that case, the employer is not obligated to pay him the wage. However, it's definitely mandatory for the employer to properly document the reason for employee's absence. Because unfortunately, if there is any investigation triggered and for a particular employer, and if he cannot demonstrate or cannot provide any such documentation where he hasn't paid to the H-1B employee for a certain period of time, and if employer cannot prove that the absence of the employee was voluntarily or not because of employer's inability to provide him the work, he may get into trouble. So better to document such type of voluntary absences which are caused by employees and not by the employer.
Good to know. What about deducting costs, such as filing fees or attorney fees from the employee's pay? Is this allowed by an employer?
No, not at all. With the increasing, filing fee costs and attorney fee cost, many times employers do ask us this question, but it is distinctly clear in the regulation that all such type of costs must be borne by the employer and not by the employee. So employer should not be deducting any such costs from the employee's wages. That's not allowed.
Thank you for explaining that. I want to ask you about the notice of LCA posting. What is the purpose of the notice of filing or LCA posting?
Yeah, so basically it alerts the workforce that an H-1B employee will be hired at a particular location and wage, ensuring the transparency and worker awareness. So it's just, I would say, it's just an intimation given to public that there is an H-1B employee who will be hired at this particular work location.
Perfect. And can you also tell us where and how must the notice be posted?
Yeah. So the notice can be posted either by posting a physical notice at at two conspicuous locations, either at the employer's principal place of business or at the intended work site. So basically, the notice must be displayed at the work site because we know what's the purpose. The purpose is to make aware people around that there is a position for which an H-1B employee will be hired. So therefore, whatever is the intended work location for that particular role, it's necessary that the LCA notice must be posted at that particular work site. Now, as I said, either it can be posted by physically printing the notice and posting on the wall, notice board, etc., or it can even be distributed electronically. So maybe like, via email, internet, or company bulletin, etc. And such notice must be posted for at least 10 business days.
Got it, 10 business days. And what about the details that must be included in this notice? Do we know what those are?
Sure. So I would say, like, basically the whole LCA information actually goes into the LCA notice. So it will have the job title, it will have the salary or wage range being offered, it will have the work location, it will have duration of employment, and then another statement saying that the LCA is available for public inspection. So basically, all the information regarding that particular work arrangement goes into the notice.
And in the case that an employee maybe works at a third-party site, in this case, who posts the notice?
Yeah, I would say this is a real challenge which many employers do face when they are like, placing their employees at the end client or at third party location. Because as we have seen that the posting requirement says that the notice of LCA filing must be posted at the intended work site. Now, if the employer is planning to hire an employee and if his work location is employer's own office, I think complying with this posting of notice requirement is easy because employer can like just post it or may email it to all his employees. But when it is with the third party or when the intended work location is at the end client, sometimes it's a little bit challenging because the premise on which you're going to like you're supposed to post the notice is not within your control. So many times employers do say that we have requested the end client personnel to post this notice, but the end client personals are not cooperating, and we don't know how we can get that done. Unfortunately, there is no clear-cut guidance where DOL is saying that if employers are able to substantiate that they had a good faith effort in trying to like post the notice at a third party site or an end client site, they will still go ahead and consider that they are complying. There is no such I would say suggestion by the Department of Labor. So I don't know when, if there are any investigations triggered for this particular reason. I'm not sure how employers will be able to justify that they have complied with this notice by showing a good faith effort to try to post this notice at the end client site. So that's practically that's sometimes a bit challenging for the employers, but I would still say that employers should document all the good faith efforts they have uh, done so that they can comply with this requirement and get this notice posted at the end client site or at the third party site.
I appreciate you explaining that for us. The last topic I want to ask you about today is record retention and audits. What H-1B related records must employers retain beyond the path?
Beyond the PAF, the employer should retain the payroll records. They should also maintain the I-9s, the employment verification document. They should also retain the employment contracts for every H-1B worker for 3 years from creation or at least for 1 year after termination. So they should keep record of all these documentations which are related to the work arrangement for that particular H-1B employee.
And what happens if an employer fails to maintain or produce a path? Are there consequences?
Uh, if the employer is not complying with these obligations, then there is a possibility that DOL may impose civil penalties on him or may request for back wage payment. Sometimes it happens that employers are not aware of the wage requirement which we have discussed, and they just pay like they just don't pay the actual wage, and they are paying less wages or to the H-1B employees. Under such circumstances, DOL may ask employer to pay them the back wages, or if the non-compliance is repetitive or is very severe, then there is a possibility that Department of Labor may debar that employer from utilizing the H-1B program.
Wow, thank you so much for taking the time today, Swapnali, to answer all of our questions on this topic. That is all we have time for today, so this brings us to the end of our conversation. Thank you, everybody, for tuning in today. A special thank you again to you, Swapnali, for answering all of our questions. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. And if you have any questions or suggestions, email us anytime at info@choop.com. Let us know what topic you want to see next, and make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care, everyone. Thank you.
Thank you.
Swapnali.